I want to introduce the next panel. We're going to start it off with point-counterpoint type of a thing. The state of Cyber Nation, Meredith Schnurr with Wells Fargo, a good friend of mine and a prominent broker here. Meredith, thanks.
We have seen such a change over the past year. For all of you that were in this room last year, it took a lot for those plaintiffs' attorneys to really succeed in lawsuits and getting past the motion to dismiss. You're going to see a change when we speak today on this panel about many of those cases that are surviving that motion to dismiss.
Sony is a story of corporate America, or corporate Japan as it may be, putting its foot in its mouth and having to pay possibly billions of dollars or billions of insurance dollars. One organization has now hacked it for the 6th time, took down the whole system. Allegedly, they hit over 100 million people's accounts, account information, financial information, other information, and the whole premise was to Sony, you get what you pay for, and if you're going to attack us, we're coming after you. Sony's response was to continue to investigate these hacks. And as Sony was investigating, it came out on the internet that people were starting to sell on various websites, allegedly sell financial information, other personal information of the PS3 users. And Sony took down the PS3 website, and they still weren't really reporting what was going on. It took over a week for Sony to finally get around to report what had happened. Sony then defended itself against all the criticism that they waited over a week to make the announcement about the hacking. Congressional investigations are underway. You're going to see more testimony in front of Congress. The Japanese government is investigating. State governments are investigating. And Sony defended itself by saying, we were gathering information and we didn't want to disclose what had happened until we had all the information, which, if you're going to wait to get all the information as a lawyer, it's going to take a long time. We're always through the discovery process, at least in litigation, as most of you know. It takes a long time. So when is having enough information enough?
If the theme today in our talk is about winning, one of the reasons that Jamie and the plaintiffs' bars are beginning to win is because the government is helping them. And when the government starts criticizing Sony for a week for notice, that's ridiculous to me. I mean, a week to send out notice with something this massive is about as fast as I've ever seen. And yet, we've got all kinds of people spouting off in the press because they want to get reelected or whatever, talking about how that's unacceptable.
I think, too, on the plaintiff side, we don't have huge firms. So when 40 firms file on a case, you have an exponential amount of resources to pursue the case. Cases could get dismissed early on motions to dismiss. Just you'd file your complaint, defense would file a motion to dismiss, and they tell their clients, oh, don't worry, we'll get this knocked out on motions to dismiss, especially in the identity theft area. But that's not happening anymore. A lot of judges have moved away, not just in identity theft, but in all kinds of cases, from the Iqbal Twombly motion to dismiss claims in federal court. And also, plaintiffs' lawyers have become more savvy on the case law, how to plead their complaint to prove injury for purposes of legal standing, so you can move forward in your case to the discovery phase. And once that happens, the coffers are open to what went wrong in the company, how they lost this information, and it can be very powerful on many levels.